beautiful Monday. Let us look at one of the documents that you really need when you want to incorporate a company in Nigeria, which is the Memorandum of Association. This is one topic that will leave your head running everywhere when you are in the classroom. But here I am giving it out to you, just dishing it out to you for free. I was with my principal recently and he was talking about a matter he handled back in the days where a transport company, you know, the matter between his clients and another transport company. I think it related to bailment, but the lawyer on the other side did not know. So while they went to court, while he was contending principal agency relationship, bailment, and all that, the counsel on the other side was busy arguing on establishing that there was a contractual relationship with them. And the judge was like, hey, counsel, the clients have passed this stage. Are you listening to the counsel on the other side? The principal just laughed. So this is why it is good to have knowledge. This is why it is good to know. So I am bringing this to you. You never can tell where the matter will come from. And for those who are into business, maybe one of your client companies, um, um, maybe being challenged, maybe there are objects being challenged and all that. The only way that you can prove it is by taking a look at the memorandum of association. And by doing that, you have to go to the Corporate Companies and Allied Matters Act. Now, when you look at Section 27 of the Companies and Allied Matters Act, you will know what is required to be contained in a memorandum of association, which is a very, very, very important document when you want to incorporate a company. Now, if you go through social media platforms, you will hear lawyers encouraging um, clients, encouraging the public, those who desire to open a company, to go ahead and register their company. Now, this is one important document that your lawyer will file on your behalf when registering that company for you with Corporate Affairs Commission. Now, there are certain requirements that are listed under the law. One is that the memorandum of association must state the name of that company. You have gone through name search, you have gotten a name, or you're already in business but you have not registered that business. Now you want to take steps to regularize the status of your business. In that your memorandum of association, it is important, one, that you should state the name of that your business. Put it down there. Okay, you will also state there that look, there's a registered office that is situated in Nigeria. This my business, we are not floating it in the air, we are not going to operate in space. It has a registered office that is situated in Nigeria. You will also talk about the nature of the business. This is what, if it is going to be a construction, if it's going to be educational, if it's going to be sports, whatever that business is, a church, it's a trust, whatever that business is for, whatever the law says, the objects, these are the things that the business is going to be concerned with. These are the activities that the business is going to execute. Okay, so you must also state it in that your memorandum of association. So sometimes a lawyer can also draft your object once you have told the lawyer what you want to engage in, can also draft and then bring to you for you to vet it, for you to look at it. If it does not actually represent what you want to do, then you can edit it and include the things that will actually cover your true intent as a business person. So also write your share capital for a company that is limited by shares. It will either be a public company or a private company. For a private company, a share minimum of 100,000 naira for a private company, 2 million for a public company, and you must show each shareholder and what that shareholder is holding after dividing that minimum share capital into several units. So each of them will also sign against their units of shares that they are holding. Okay. So for somebody who is also holding shares on behalf of another person, it must also be stated in that memorandum. For instance, if there is a person below the age of 18 who is actually entitled or who is a member by reason of persons not disqualified by age. Now, if there's somebody who is also holding for that person, maybe until he gets mature or he becomes of age, that person must also state that information, and the name of that beneficiary must also be stated there. After they have done all of this, they are all going to append their signatures there as well. Now, apart from having a company that is limited by shares, which can either be a public company or a private company, you can also have that which is limited by guarantee. So if you're also registering, if you desire to register a company that is limited by guarantee, which means there is no specific minimum share capital, the parties will have to undertake that in the event that we can no longer continue with this business and we desire to wind up, each member of this company is going to contribute so and so to the process of winding up this company. And it must be stated like that on the face of the memorandum of association. Even the cost of winding up will also be undertaken by members of that company, a cost that will not be less than 100,000 naira for each member of the company. And there are restrictions if it is a company that is limited by guarantee, where the property of the company cannot be transferred to any member of the company except in situations where it is permitted under this act. So for you that you want to open a company, like I said, the choice of company that you want to incorporate will determine your level of liability. Now, if it is a company that is limited by guarantee, I have told you before that the members will undertake at the point of winding up the debts of the company, the liabilities of the company will be borne by every member of the company, both those who are currently members of that company and those who were members of that company a year preceding the time they have decided to wind up the company. So you cannot even turn around to say, okay, 1 year ago, last year, I stopped being a member of that company last year. So long as it's a year preceding the time of winding up, you will still be bound by the debts and liabilities of that company. Okay? So this is Zivia Law Essence. This is where we give you premium legal tips. I remember those days as undergraduates, we used to call company law Bible because it is wide, it is tricky. This is one aspect, this preliminary aspect of company law that will keep your head running everywhere because you want to differentiate it. You want to differentiate it from other documents. You want to find out what it entails. You want to find out what is contained. What is the true nature of a memorandum of association? But here I am. I'm giving it to you for free of charge. We'll see you again. This is Zivia Law Essence. Here we give you premium legal tips to help you make informed decisions, live informed lives, and discover the best version of yourself. We'll see you again.